Hello, friends. Today's topic is about financial establishment and depositors' safety. This act was brought into existence in the year 1999 under the name of the Andhra Pradesh Protection of Depositors of Financial Establishment. The depositors are being cheated and are put to grave hardship by losing their hard-earned savings. To curb these malpractices, the state governments have decided to bring a law for protecting the interest of depositors a financial establishment in the state and for matters connected with or incident thereto. The central government has given direction to different courts in different states for bringing up with a act which can safeguard the rights of the depositors in different financial institutions like small scale chit funds companies or small scale chit funds, those who are being operated by different people in different localities like small areas where individuals will run small chitties and they'll get their subscribers and after running the chits suddenly they will disappear or they will close the chit fund activities. What will be the fate of the depositors? So this is the act which was brought into existence to safeguard their rights, and the section which is given as conviction under section 5. And if some institution which runs the chit fund, if they will allow from the area, or there is a chance that they will allow by closing the shutdowning the chit fund, their properties can be attached by the state government by issuing a order under section 3 or 4, and the punishment only under section 5. If someone is doing it or they have allowed from the area by closing the chit fund, the depositor can give a complaint to the concerned officer or police station where the chit fund is located. Under section 5, the case will be registered against the chit fund company or chit fund operating person, and his properties can be attached if some properties are there with him, or during the course of chit fund when he is operating and he has earned certain properties, his properties can be attached under section 4 and 3 of the act, and those property will be disposed of by the government under attachment, and by curing the amount or the sale of those property, whatever amount will be incurred by the government, those will be distributed among the subscribers of the chitties, and such is the case. And the person can file petitions, and his insolvency petition is also filed. The person can challenge those petitions, the subscribers. These are some of the sections under, and special courts will be constituted to try these cases, and under the provision of law, those courts will be session courts. A special session court will be given power to run this case or try these cases under this act. The Financial Establishment Act 1999, Section 4 says, the competent authority shall apply within 15 days to the special court constituted under this act for making the interim order of attachment of absolute property of the chit fund operator. And subsection 3 shall be accompanied by one or more affidavits stating the grounds on which they believe that the financial establishment has committed any default or is likely to default. This is section 4 which says, and penalty will be under section 5. Every person responsible for the management of the affairs of the financial establishment, including the promoter, manager, or member of the financial establishment, shall be punished. The term will be 10 years with fine which may extend to rupees 1 lakh, and such financial establishment shall also be liable for fine which may extend to rupees 5 lakhs. This is the provision of law with regard to chit funds, and attachment of property will be done as per section 8. The attachment of property is certain transferee. If it is known to the investigating authority thus that the attachment, the properties directly is not standing in the name of the chit fund operator, his relative's name or his well-known name. Those properties can be also attached under Section 8 of this Act, and how the administration of property attached should be done by the authorities, that is there in as per Section 10 of the this, and the appellant authority will be the High Court. If someone loses a case or a conviction is accorded in that particular offense, and he can apply to High Court and appeal such is case in the this particular act. And the power of the special courts are under Section 13, and the governments can make rules as per the prevailing scenario day to day. And the section is under Section 18. The act gives power to the government. Government has the power to make rules for the feasibility and the trial of those cases or attachment of those properties and the person who are running those chit funds. This act came into picture in the year Act 1999, and a bill was passed 39 of 1998 as per the governor's order. A gazette was published as 14(4)(b), extraordinary gazette was published, and this act was brought into existence for the safety and the safeguards of the depositors who has deposited their money or the subscriber for any chitties. So these chit operators property can be attached as per this provision of law, and the person who was connected to the chit fund operator, his relatives, his well-wishers, or if some source says that those amounts were being deposited in someone else's name or some properties were being uh, purchased through those incomes or through those chit fund amount, those properties can be attached by the state government when the court can pass an interim order to attach those properties until the disposal of the criminal cases. This is the provision of law with regard to small chitties or chit fund companies and the safety of the subscribers or the depositors, because the depositors, they don't know when the operator can shut down or to close the company or chit fund company or the financial institutions. They can file a case under Section 5 before the concerned authorities, and a prosecution will be held against those people. Thank you very much, friend. My name is Srinivas. Thank you.